Me and Amalia are doing our presentation on Brexit. These are the 5 principles of the British Constitution that we're going to look at, and we're going to see how Brexit has affected them.
The first principle of the British Constitution is rule of law. All laws must apply to all people at all times, all in the same way. During the period of leaving the European Union, the British government broke the rule of law multiple times. Firstly, the Internal Markets Bill of 2020 would have broken international law if a Brexit deal wasn't calculated. However, the government still supported the bill even though it would break the international law under Article 4 of the Brexit Withdrawal Agreement. The bill outlined the arrangements for trading within England, Scotland, Wales and Northern Ireland. Secondly, the Supreme Court have ruled that the proroguing of Parliament for 5 weeks was unlawful. Supreme Court judge says, it was unlawful as it prevented Parliament from carrying out the constitutional principles without a reasonable justification.
So for parliamentary government, Miller 1 was a dispute in 2016 where Gina Miller took the UK government to court for taking the UK out of the EU without legitimate law allowing them to do so. The courts agreed with Miller, saying that the UK got into the EU by Parliament and therefore must only leave the EU also by Parliament. The legislation that entered us into the EU was the EU Communities Act of 1972, and the now passed legislation allowing us to leave the EU was the EU Withdrawal Act of 2016. The Miller 1 case clearly shows the government not abiding by parliamentary government, as they are not working through Parliament in order to create the sufficient legislation needed for the UK to leave the EU lawfully. In 2019, Gina Miller took the Prime Minister to court. The allegation was that the advice he gave to Her Majesty the Queen regarding that Parliament should be prorogued from a date between the 9th and 12th of September until the 14th of October was not lawful. The Miller 2 case demonstrates that the Prime Minister was not abiding by parliamentary government as he was attempting to prorogue Parliament for an unnecessarily extensive amount of time, and therefore meaning he wouldn't have to work through Parliament and also would not be held accountable by them.
The unitary state of the United Kingdom was challenged by Brexit, with Scotland's majority voting to remain in the UK in September 2014. 55% voted to remain and 45% voted to leave. However, Scotland also voted in the 2016 EU referendum to remain in the EU, even though the majority of the UK voted to leave. 62% of Scotland voted to remain. The Scottish Government are now proposing a second referendum on Scottish independence from the UK. More than 230,000 Europeans have made Scotland their home, and Scotland wants to keep the freedom of movement that they received from being part of the European Union. The unitary state of the UK has also been challenged with Northern Ireland due to Brexit. The Good Friday Agreement of 1998, that put an end to the troubles between the Catholics and Protestants in Ireland for decades, declared that there will be no harsh border between Northern Ireland and Southern Ireland. However, Brexit has challenged that Northern Ireland is still in the UK and has now left the EU, so there is no distinct border between the UK and the EU. Because of this, the Irish Sea has become an effective border between the UK and the EU, even though Northern Ireland is still in the UK. From the 1st of January, commercial goods entering Northern Ireland from Great Britain require a customs declaration. Food products have to be inspected by the Department of Agriculture. They also need health certificates. There are also new checks and controls on freight arriving at the Dublin border from Great Britain. Irish Foreign Affairs Minister Simon Coveney said, "We are now going to see £71 billion worth of trade across the Irish Sea between Britain and Ireland disrupted by an awful lot more checks and declarations, and bureaucracy and paperwork and cost and delay. This poses the huge question, the same as Scotland, will Northern Ireland want to stay in the UK? The Good Friday Agreement also stated that if people of Northern Ireland want a reunification, a referendum will be held. This gives us reason to believe that the UK is becoming more of a quasi-federal state rather than a unitary state, due to Scotland and Northern Ireland both having their own governments, but will always have to obey by the British government if they decide to take their power away."
Parliamentary sovereignty. So when the UK joined the EU law would not allow UK legislation to be passed that was not compatible with EU law. They overruled the domestic rule of law. However, now the UK has left the EU, Parliament has regained more power and sovereignty and immediately started to demonstrate their powers as the legal sovereign. For example, they removed the tax the UK forced you to have on women's sanitary products. The UK left the EU on the 31st of December 2020. And they implemented the removal of VAT on sanitary protection on the 1st of January 2021. This clearly demonstrates that parliamentary sovereignty and Parliament as the legal sovereign has been strengthened due to Brexit. Furthermore, this emphasises the government's power as policy sovereign, as they now have more freedom in regards to writing the UK's own policy without it having to abide by EU standards. However, on the contrary, many fishermen and fishing companies supported Brexit as they believed they would gain more land to fish in privately, as they wouldn't have to abide by EU fish for EU fishermen, and it would now be British fish for British fishermen. But due to many places in the EU being major trading partners, the British couldn't afford to lose them as allies and therefore was very limited in improving conditions for fishermen. They thought that they would be allocated exclusive rights over waters 12 miles from the coast, but they have only got 6 miles, which was the same as before. This demonstrates that although UK's Parliament has more legal sovereignty than before, they still can't create the exact legislation that would be liked, as they must maintain the alliance with the EU. This also applies to the government having limited policy sovereignty.
On the 28th of August 2019, Boris Johnson advised Her Majesty the Queen to prorogue Parliament in preparation for the Queen's speech on October the 14th, 2019. Constitutionality of government can be evaluated in 3 ways: compatibility with the law, political convention, and constitutional principle. The act of proroguing was compatible with the law, as it is a normal preparatory step for the announcement of a new legislative agenda in the Queen's speech on the 14th of October. It was also compatible with the political convention, as the Queen is a hereditary monarch. Her role is to be head of state and rise above party politics. By political convention, she acts on the advice of her Prime Minister, in which she has done in textbook fashion by approving the order without delay. Although the proroguing of Parliament is constitutional in terms of constitutional monarchy, it is not due to the parliamentary government, as government went against the advice of Parliament, making the act undemocratic, as the Prime Minister is not democratically elected, but Parliament is. Before Brexit, it was mandatory that every piece of legislation passed had to align with the treaties and laws of the EU, whether they were regulations, directives, decisions, recommendations, or opinions. However, now that the UK has left the European Union, these rules no longer apply. Boris has directed civil servants to scan through tens of thousands of pieces of legislation and statutory instruments, which covers 47 years of EU membership. The Sunday Times have called the Operation Bleach. This is thought to help to avoid any potential misunderstandings and the need for any future interpretation from the European Courts of Justice, yet the process is still ongoing.
Due to David Cameron being a part of a coalition government with the Liberal Democrats for 5 years, it potentially demonstrates a prime ministerial form of government. By nature, he had to manage from the middle due to the strange form of government called a quad government, meaning a one-off anomaly. It was an ad hoc reaction to a specific set of circumstances. After the coalition government, Cameron didn't have enough time to impose a model of government because of Brexit, although I don't think that Cameron is inclined to govern from the centre, certainly not in the same way Blair was. Theresa May clearly took a cabinet and collegiate form of government. There was clearly much collective decision-making and lots of formal cabinet meetings. There were clear lines of accountability and responsibility during her time as the executive. Although May did act more presidentially when she called for the general election in 2017, which she won. Regarding Brexit, many of the decisions were made by the Brexit Secretary, who was David Davis. Although due to her having many formal cabinet meetings, there must have been much discussion regarding Brexit, and therefore it was handled collegiately and in a cabinet government style during May's time as Prime Minister. Boris Johnson has a much more presidential style of government, although it is not that presidential compared to Thatcher's form of government by the end of her years as Prime Minister towards the end of the 1980s. I believe he has chosen this type of style as he saw from May that being collegiate would not pass a Brexit deal, although this style of government clearly did work for him as he did manage to pass a Brexit deal on the 31st of December 2020, which is the European Union Future Relationships Act.
Brexit has strengthened British democracy due to high participation. Turnout in the EU referendum was 72.2% compared to the 65.1% in the 2015 general election. It has gone up 7.2%. The voting turnout for the 2019 election was 67.3%, which is a decrease from the referendum, but an increase of 2.2% from the 2015 general election. Also, by calling a referendum, it gave the people the choice rather than just the government deciding on our behalf. Britain got in through the United Kingdom European Community's membership referendum, so they should get out by a referendum and let people decide, in which they did. The EU is often accused of being opaque and unaccountable, so by Britain leaving the EU, it might make Britain more transparent and democratic. However, it has also weakened democracy as it has caused a split across the country, creating a hostile government between Remain and Leave. Many citizens don't have working rights, don't have voting rights, even though they have citizenship and have lived in Britain most of their life. This has resulted in many of the country not being able to express their views, which is severely undemocratic. In 2016, at the time of the referendum, people were ill-informed. People were led to believe that remaining in the EU would cost households £4,300 a year by 2030, which is incorrect. The day after the Brexit referendum, the most Googled search was, "What is the EU?" This is very undemocratic as the people were voting uncertain on an extremely important decision. Brexit has also taken away our freedom of movement. As British citizens, we can no longer move freely between each EU country. Yet it also means less freedom of movement for EU residents as they can't live in the UK without registering residence as a part of the new point system. It also means that EU citizens with a criminal record can't enter the country. Freedom of speech has also been exercised during the Brexit campaign, with more of the youth getting involved and more people expressing their views.
These are the sources we use to find everything in this presentation.
Thank you.
Thank you.
Now, Cate and I will talk about the impacts of COVID-19 on our constitution. After the COVID-19 pandemic hit the UK, unprecedented steps needed to be taken to slow the spread of the disease and save thousands of lives. These words were included in Boris Johnson's speech just before introducing the first lockdown on March 22nd. Concerns arose questioning whether lockdown was lawful and democratic. These are the questions that will help us understand the impact of COVID on the government and broaden our knowledge of the Constitution.
To first understand the impact of COVID on our government, we need to understand the principles of our Constitution and how they have been disobeyed during the pandemic. The first principle is a unitary state, which hasn't been seen during the pandemic. An example is the cancellation of GCSE and A-level exams this year, where Scotland and Wales cancelled these external exams in early December, and until a month later, English students would have held an unfair disadvantage in comparison to the rest of the UK.
The second constitutional principle is the rule of law, meaning that everybody must abide by the law and no one is above it. This was violated in May 2020 by the Prime Minister's chief advisor, Dominic Cummings. He drove across the country to his second home during lockdown, breaking the restrictions that were in place for everybody. His actions were later excused by Boris Johnson, proving to people that people with power can bend the rules and not get punished, unlike everybody else in the UK.
The third principle is parliamentary sovereignty, and another principle of parliamentary government comes into this. Parliament is the legal sovereign in the UK, which can create or end any law. However, during the pandemic, this was somewhat ignored as the creations of new COVID regulations were mostly done by ministers instead of Parliament as a whole. Parliament could say yes or no to a new regulation but had no opportunity to amend anything. This created a rubber stamp parliament. Furthermore, the fourth principle of parliamentary government was somewhat ignored as laws were not made by a true majority vote, with time taken to review new laws and then signed by the head of state.
This point, which I'm going to talk about, directly affects us and affected us in the past, is individual versus collective responsibility in relation to cabinet government. After the uproar of last year's A-level results, Gavin Williamson, the Secretary of State for Education, didn't take individual blame for his mistakes and threw Ofqual under the bus, resulting in the resignation of the head of Ofqual, Sally Collier. Instead of making Ofqual take collective responsibility, Gavin Williamson should have taken individual responsibility for his actions and resigned. Lastly, I'm going to talk about human rights during COVID and the battle between different rights. As we know, on the 4th of January 2021, Johnson addressed the nation, introducing a third national lockdown and a second round of school closures. One could argue that a number of human rights as seen in the Human Rights Act of 1998 and the European Convention of Human Rights, which both the UK have signed, have been violated, including Protocol 1, Article 2, the right to education, and Article 11, the freedom of assembly. The closures of schools is breaking the Convention of the right to education, particularly those who have no access to virtual learning simply because their school may not provide or they cannot afford the equipment and space to recreate an appropriate learning environment. One can also argue that children in abusive households might have a violation of Article 3, freedom from degrading treatment. Additionally, several other human rights, including the right to movement and the freedom of assembly, have been violated because of another national lockdown, where fines are put in place for those who travel unessentially and those who gather in large groups. However, we believe that in this particular case of a deadly virus affecting our country, some human rights must be broken in order to protect the greater good. The United Nations Conventions of the Child stated that a government can restrict the enjoyment of some human rights for the protection of public health, but restrictions should be kept to a minimum. We agree with this because in this situation, human rights need to be weighed up against each other to find the best outcome for the public. The right to life outweighs the freedom of movement, especially when freedom of movement and freedom of assembly of a person or a group of people can be fatal to another person or another group of people. This was a dilemma the government faced a few weeks ago. Keep schools open and risk the lives of education workers in vulnerable households, but keeping the right to education, but risking the right of life or close schools and keep education workers and families safer, risking the right to education for those unable to make virtual learning possible, but minimising the death from the virus. Evidence fueled the balancing of rights. An example of this is 23,557 people were admitted to hospital because of COVID in 1 week, recorded on the 4th of January 2021, in comparison to the average of 243 people admitted to hospital each week in August 2020. So, although some may argue that their human rights have been violated by not being able to travel to a different household, we have seen evidence that suggests that too many people are losing their most important right, the right to life, because of other rights being able to take place.
In conclusion, the pandemic has helped us to understand the Constitution by looking into the principles of the Constitution and seeing how factors such as the new regulations and breaking lockdown restrictions have affected them. We can also look at the impact of COVID-19 on our government as we see the damage that it is doing to, in some cases, the integrity of our politicians and our country as a whole.
These are the sources that we use to find everything in our COVID presentation. Thank you for listening to our presentation on Brexit by Sabyn and Amalia and on COVID-19 by Cate and I.